On this episode of the program, we bring you highlights from the Great Homecoming Colloquium of the University of Lagos Law Alumni Association. Also showing on the program, senior lawyers share their thoughts on the move by the lawmakers to increase the number of law school campuses. In other news, senior advocate of Nigeria, Olisa Agbakoba, has been speaking about driving economic growth through legal innovations. What's that about? We have details coming up, plus our weekly recap of the top legal stories. Hello and welcome to the program. I'm Shola Shieli. The buzz had been on for a while. They tagged it the Great Homecoming 2022. On Monday, February 7th, the University of Lagos UNILAG Faculty of Law Alumni Association kick-started activities to mark its inaugural reunion. The 5-day event saw some distinguished alumni members of the faculty invited back to the school to serve as guest lecturers to students on courses on the faculty's timetable. On Thursday, February the 10th, it was time for the colloquium. The major highlight of that event was the keynote address of a past alumni, Professor Fidelis Odita, QCSAN, on the very topical issue of stare decisis and the future of legal practice. Here's the report. The colloquium, which held on campus, attracted a large number of distinguished alumni members of the Faculty of Law, members of staff, lecturers from other faculties, students, and other invited guests.
We have here before us an array of judges, lawyers, senior advocates, the who and who of the legal profession in Nigeria, and of that we are extremely and profoundly proud. The colloquium here today is part of a series of events that we have organized as the Alumni Relations Committee in conjunction with the Faculty of Law to bring back our alumni to the faculty.
Your faculty was established almost 60 years ago as one of the maiden faculty of law, of maiden faculty of the University of Lagos. Ever since then, the faculty has gone ahead to produce what we call fit-for-purpose lawyers and captains of the industry. Today, I know of no faculty of law that has produced, as we speak, not less than 4 sitting justices of the Supreme Court. We have, as we speak, not less than 100 senior advocates of Nigeria from faculty of law. So we have every reason to celebrate because we are consistent. But you and I know that in legal system and legal methods, the first thing we are told or taught is stare decisis, or to break it down to non-lawyers, still lawyers also, judicial precedents. That remains the cornerstone of our legal system. That take away judicial precedent and stare decisis, there will be confusion and anarchy. What it means is that similar cases must be decided similarly unless it is overruled by the Superior Court. That means that in our profession, there is law and order. But today we are here to discuss serious business. We looked at the various decisions coming from the Apex Court and Court of Appeal, and we are able to find conflicting decisions. And as lawyers, we are unable to advise clients properly.
If our decisions are not predictable, it puts a cost on negotiation. It also adds more cost to seeking justice in our judicial system. The micro aspect of it is that for those that are investing in the country, they also study all of these issues. How predictable our judgments, how reliant, and how stable our decisions of courts. Because all this affect them in their own investment decision making.
The keynote speaker is a past alumni of the faculty who has distinguished himself as a scholar of repute. First, he makes the point that the efficiency of judicial precedents is based on a robust system of law reporting. Then he speaks about 3 broad aspects of the application of precedents.
The first is what I regard as precedent and jurisdiction. And you shouldn't blame me for that. I'm really very traumatized by the invocation of jurisdiction in Nigeria. Because having litigated for more than 30 years in England, I haven't come across jurisdictional issue more than once or twice in 30 years. But every day in Nigeria, I'm confronted by jurisdiction. In fact, when I went to court on Tuesday, I had 8 preliminary objections against me. So I told the judge that this is a season of objections. Here I am with a simple case, and I have 8 objectors. No one wants to come for a trial. The second is what I would regard as, describe as precedent and prospective overruling. And finally, of course, precedent and conflicting decisions. And that's why when people criticize Nigerian courts, in general, they do well. But they are troubled by 2 types of cases: big commercial cases and big political cases, especially election results. And what is common to those 2 types of cases is money. And let me tell you, one of the things that I face, and I've given so many expert opinions for Nigeria, especially in relation to the enforcement of large arbitral awards against them all over the world. I've probably given more expert opinions than most people. One of the things they complain most, why they don't want to come to Nigeria to enforce the award, is because of the judiciary. And so I have, I have the difficult task of trying to persuade these foreign courts that there's absolutely nothing wrong with Nigerian courts. These courts that I go to, and then I have to go there and say to them, everything is okay. These courts are just troubled by a few things. The distinction between jurisdiction and admissibility, there are registries that don't work, the delay in the system, the fact that some of the judges are incompetent, the fact that some of the judges lobby to be appointed and forgot what their role should be, the fact that some of them don't turn up until 11 a.m. and they tell you they stopped at the ATM to withdraw money. And you can continue. But that's because they have set their own standards very low. And they think that anything they say is an excuse for coming late. So that system is challenged. Not because the people are not good people, but because we don't understand what the appropriate standard should be. If you understand what the appropriate standard should be, to lobby for a job is not itself a problem. It's how you discharge that job after you've been given the job.
But what does the future look like? Here's what the professor had to say.
In my view, 4 things will shape the future. The first is this distinction between jurisdiction and admissibility. And unless we teach the judges this distinction, we're not going to make any progress. First of all, there will be widespread misuse of jurisdictional objections. They will waste the litigants' money, and they will delay the resolution of cases. That's the first, and the judges must understand that. The second point is that the quality of the advocates who appear, the quality of the advocates, because it's all very well to mock the judges. What about the advocates themselves? I'm not talking about those who wear bedroom slippers to court. That's different. Those are just caricatures, because as you all see, all you law students aspiring to go to law school, I'm sure you won't turn up in court with bedroom slippers. But the quality of the advocate determines the quality of the submissions made, and therefore the quality of judgments. You don't expect these judges who are doing 20 things at the same time to carry out any research. So you ask yourself, if you go to the law reports now, take 2017 to now, and go back and take 1990 to, or 1986 to 1995, and see the difference in the judgments. One of the first things that you will notice is the extent of analysis in those older judgments. And then you compare that with this more recent incarnations of the law. And you see that there is no analysis. They just tell you, in relation to illegality, est topic causa non oratio actio. Applying this is the answer. That's a catchphrase. Or they tell you, impari delicto potio est conditio defendantis. And you're saying to yourself, at the time that everybody is trying to simplify law, these people are still taking refuge in Latin maxims, which at best confuse. Thirdly, the quality of the judges. It is very difficult to make progress if the level of incompetence and mediocrity prevalent in the judiciary is not addressed on an urgent basis. We have noticed that nepotism is rife in the recruitment into the judiciary. The judiciary is poorly funded and poorly remunerated. They have shown little capacity or inclination to discipline themselves. And so you see all those funny judgments that they give, exculpating themselves. Even when they have stolen money, they say, until my discipline is exhausted, you can't bring me to court, rat, rabbit. So they are setting their own standards so low that it's almost gotten to vanishing point. And you're asking, do they actually understand the judicial function? Reform is urgently needed, and we need to look at the recruitment, remuneration, promotion, and discipline of judges. At the moment, it appears that notwithstanding the clear provisions for judicial independence in our Constitution, the judiciary has largely surrendered its powers, especially in relation to recruitment, to politicians. You cannot be promoted as a judge without lobbying politicians. And as surprising as it might seem to you, that is the reality. So try and see whether you can get to the Court of Appeal from the High Court. They will ask you, do you know the Senate President? Do you know the Speaker of the House of Reps? Do you know the Deputy Senate President? And you're asking yourself, but they're not part of the process. The NJC and the Federal Judicial Service Commission is made up largely of lawyers. How did these lawyers surrender their powers to politicians that you cannot get appointed or promoted unless somebody puts you there? But we all know what happens with puppets. When you have puppets, it's the puppeteer that determines what happens. So a lot of the judges are puppets, with all due respect to them. So that has to be addressed. But of course, we also have to address the big elephant in the room, which is the small matter of corruption. But let me tell you, corruption is not just about taking bribe. And people often miss. A lot of cases are thrown, not because the judge took money, but because the judge wants to do a favor to someone. It's not because somebody brought... The judge thinks that his or her position is a personal privilege, and so is there to dispense gifts to people. If you steal a chicken, you go to jail. But if you steal your state money, you can hire us, and then you won't go to jail. Not because the law is different, but because the judges feel unable to resist the pressure imposed both by the litigants themselves and the advocates. The final influence on the future of stare decisis is the extent to which Nigerian courts are willing to innovate.
After this keynote speech, a panel of alumni students made up of representatives of the three arms of government and the academia also looked at the issue from their different perspectives.
So for me, as a legislative arm, we are burdened for the fact that we are not sure in what way our law will be interpreted and in what way will be applied. But I believe that there are certain reforms we need to be thinking about. We need to deepen our legal education. We need to address overburdened judiciary. We need to expand the capacity, particularly of the intermediate court, the Court of Appeal. I hope the proposal to have minimum of 100 judges at the Court of Appeal will stay through the recent constitutional amendment.
Where there is no law, there is no offense. And it is the hand that sinneth that will be caught. So if you don't cut the hand will keep on growing longer and be restricting further beyond where it should go. So we need sanctions, not only for judges, but also for lawyers. We should also think about dealing with the problem of corruption in election. Take it out from the judiciary. Let's have constitutional courts that is not made of only lawyers, but made of people of integrity. And let them be tenured. You serve there for 4 years. If you do good, you have a second year. If you don't, you get out. And let's have clean system of education that. And lastly, if I don't say this, I'll be doing disservice to myself as an Attorney General of a state. There is over-federalization of our judicial system. We must, in thinking about reforms, always think about the sub-national groups that make the state. If you are thinking about increasing the number of courts of appeal people, think about establishing court of appeal in the state so that there won't be many cases going to those places.
As judges, we are on the lowest rung of the judiciary ladder. So when the Supreme Court coughs, we too, we have to cough exactly like that. When the Court of Appeal also coughs, we have to follow their own precedents. It doesn't necessarily make the work easier. It doesn't necessarily mean that we're not thinking. Because you see, binding precedents only work when the facts are exactly on all fours with each other. And so you have to scrutinize. First, you read that precedent that is being cited to you. Then you look at your own case. Are they exactly on all fours? Is there any material way, a distinguishing factor? And so if there's a distinguishing factor, then I do not necessarily have to be bound by something that I consider to be erroneous.
On the sidelines of the colloquium, I spoke to 2 law professors about the move by the lawmakers to increase the number of law school campuses to 14. The existing law school campuses are located in Lagos, Abuja, Kano, Enugu, Yola, Adamawa, Yenagoa, and Port Harcourt. The additional campuses approved by the Senate are to be sited in Kaba, Kogi State, Jos, Plateau State, Meduguri, Borno State, Agungu in Kebbi State, Okija in Anambra State, Orogun, Delta State, and Ilawe in Ekiti State. The chairman of the Senate Committee on Judiciary, Human Rights and Legal Matters, Senator Payemi Bamidele, said creation of the new school campuses was a legislative intervention to address the exponential increase in the number of law graduates from the universities and foreign ones, coupled with the backlog that existed over the years. But the 2 law professors say the creation of additional campuses has become a political issue.
I think it's a thoroughly bad idea. It's a step in the wrong direction. Already we have a proliferation of law schools, so the idea that they want to create 6 or 7 more is almost mindless. First of all, they have to ask whether these law school graduates are able to serve their employers. Are they ready for practice when they come out? As far as I'm aware, and this is the opinion shared by many senior lawyers, these people come out, they are not ready to practice. So the idea that you want to create more centers where people who have not acquired any skills and you've wasted their time for 1 year should go to is one which is obviously in the wrong direction. What they need to do is either to scrap the law schools completely or to take the funding which they want to put in these 6 or 7 new institutions and use to augment and upgrade the existing institutions.
We have to rethink the whole idea of the law school system in the modern, time that we are living in. In other jurisdictions, this idea of law school is being phased out. So what you do is that you constitute the Council of Legal Education into an examination and certifying body. So all the courses they are teaching can be taught in the university. And then you can then necessarily increase the years. So if they spend 1 year, add that 1 year, spread those courses. It's even better because some of those courses are dysfunctionally taught. So you are teaching me criminal law. I don't know what I need to do to be able to prosecute somebody. When I now finish criminal law, years later, I took criminal law at 300 or 200, then you now come and teach me criminal procedure. And it's a bit dysfunctional. I'm a member of multiple, bar. The other one, I sat for exam because I went to the university. And there will be tutorial centers where you can go online, prepare yourself, sit for the exam without the stress of looking for money for accommodation, looking for money for travel, people dying on the road, security challenges. We have to think within the milieu of what is going on. Even the law school are done virtual. So law school can then break out. You don't need to keep young people, provide for this, and let those things be decentralized.
Welcome back. In other news, Senior Advocate of Nigeria, Olisa Agbakoba, has been speaking about driving economic growth through legal innovations. He says that the country is facing enormous economic challenges and needs massive revenue to meet existing obligations, which only a visionary leadership can deliver.
There are fallow assets estimated at $900 billion. Do you know what that means? $900 billion. That is our money, according to PwC. So you can Google PwC report to get it. Now, the Attorney General Malami commissioned a couple of consultants to go around and retrieve all abandoned government assets. In Onitsha, just next to me, is an abandoned federal government public works assets, first built by the whites. So there is money. So why should the president of Nigeria not put his teeth into the 900 billion? Is there any reason? I don't see any reason. So part of what is important is to say, to what extent does government have a clear understanding of the role between law and the economy? One example is the Ports and Harbour Bill, which has been lying in Parliament for 13 years. Yet we have such dilapidated ports, and the government doesn't have revenue. So if the government wishes to raise revenue, it has to pass the law. And when that law is passed, it gives confidence to investors, whether domestic or foreign, to put in their money. So that's one driver. So we can go look at, for instance, in the judiciary, it was mentioned that as a result of the weak legal framework around the justice sector, we have about 3 trillion trapped in that sector. Now, it's only when the legal framework is modernized that that money can come out into the system and be useful. So law does have a big impact.
Away from that, the Supreme Court has declared as unlawful and unconstitutional Executive Order Number 10 on the funding of state judiciary and legislature. In a split decision on Friday, the 11th of February, a majority of the court's 7-member panel agreed that the president exceeded his constitutional powers in issuing the Executive Order Number 10. 6 of the 7 members of the panel proceeded to void and set aside the executive order issued by President Muhammadu Buhari. The Apex Court also dismissed the 66 billion naira suit filed by the state governors against the federal government. Let's now bring you a quick recap of some other top legal stories in the news.
We begin with the report that the Supreme Court has fixed May the 6th for judgment in a legal tussle by Rivers and Imo state governments over the ownership of 17 oil wells in their territories. The Apex Court fixed the date after lawyers involved in the oil ownership tussle adopted their written addresses. While adopting his final address, the Plaintiffs' Counsel, Senior Advocate of Nigeria Joseph Daudu, asked the Apex Court to give judgment in favor of Rivers State on the grounds that the historical evidence right from 1927 till date clearly indicates that the oil well belongs to the state. In their arguments, however, counsels to Imo State and the Attorney General of the Federation asked the Apex Court to dismiss the suit on the grounds that it ought to have originated from the Federal High Court. In Port Harcourt, Rivers State, a federal high court has asked the Economic and Financial Crimes Commission to stop further action against the former governor of Imo State, Senator Rochas Okorocha, until the determination of the case before it. Through his lawyer, Senator Okorocha had approached the court to seek the enforcement of some orders earlier made in his favor in a case brought against him last year over claims he mismanaged the sum of 5.7 billion naira when he served as governor of Imo State. The claims were allegedly made without inviting him for interrogation, an action, he says, was an abuse of his fundamental right to fair hearing and presumption of innocence. Justice Stephen Pam frowned at the fresh charge against the former governor, despite an earlier order to halt further action. He reiterated his order before adjourning the proceedings. In Lagos, a consultant pathologist with the State University Teaching Hospital, LASUTH, Dr. Sunday Osheyemi, has told the coroner inquest into the controversial death of the Darwin College student Sylvester Oromoni that a blackish substance was found in the boy's intestine during autopsy. While answering questions on the cross-examination from counsel to the Oromoni family, Senior Advocate of Nigeria, Femi Falana, Dr. Shoyemi, however, testified that no test was carried out to determine what the blackish substance was, as LASUTH had no toxicology laboratory to conduct the test. He also testified that the necessary fluids to conduct the test was not available following the initial autopsy in Warri Delta State. The deceased's father had alleged that his child was beaten by some senior students and forced to drink a liquid that killed him, but the school denied the claim, alleging instead that he sustained injuries while playing football with his mates. And we round off at the Kano State High Court, where proceedings were stalled on Monday, the 7th of February, in the case of 5-year-old Hanifa Abubakar. 3 suspected killers, Abdulmalik Tanko, Hashimu Isiauku and Fatima Bashir, had earlier been arraigned on February the 2nd before Chief Magistrate Mohammed Jibril on a 4-count charge of kidnapping, culpable homicide, conspiracy, and concealment of a child. The matter could, however, not go on at the Kano State High Court before Justice Usman Naabba, owing to a lack of legal representation. The court granted an adjournment to enable the state government to provide legal representation for the defendants.
That's the show. Thank you for watching. Please catch up with past episodes on our YouTube page. I am Shola Sheyele. See you next week.